And Lisa Rubin, I just want to read, because it's important that we listen to every single word of Judge Cannon's decision. And let me just read you the concluding statement on this 93-page decision. For the reasons set forth above, it is ordered and adjudged as follows. 1, defendant's motion to dismiss superseding indictment based on unlawful appointment and funding of Special Counsel Jack Smith, granted in accordance with this order. 2, the superseding indictment is dismissed. 3, this order is confined to this proceeding. The court decides no other legal rights or claims. 4, this order shall not affect or weaken any of the protections for classified information imposed in this case or any protective orders pertaining to classified information. 5, the clerk is directed to close this case. Any scheduled hearings are canceled. Any pending motions are denied as moot. Any pending deadlines are terminated. Done and ordered in chambers at Fort Pierce, Florida, this 15th day of July 2024. Lisa, your reaction to this?
Well, you know, Jose, if you were just writing an opinion for lawyers where you say the case is dismissed, you stop. The way in which Judge Cannon structured her language at the end of the opinion suggests to me that she's writing for multiple audiences, and those audiences include our viewers and the general American public. She is trying to make absolutely abundantly crystal clear what the ramifications of her decision are today, not just to people like me, but to our viewers watching it at home and anybody else who has an interest or a stake in this proceeding. And as you said, what dismissal means is that any other motions are moot, any other hearings are never happening. This is a final decision of this court. The good news in that is that it can be appealed. But as you and Chuck Rosenberg were talking about earlier, the timeline for any appeal would likely, unless expedited, extend far beyond the general election timeframe. There are a couple other features, Jose, if I can, that I'd like to point out to you and our viewers. One of the first things I want to think about is that there were 7+ motions filed by Trump and his co-defendants to dismiss this case. This was always one of them, and yet it was not one of the first that Judge Cannon took up. In fact, she took her time in getting to this in June, despite the fact that the motion was made in February. And then just a few weeks ago, after hearing oral argument on this motion based on Jack Smith's allegedly unlawful appointment and appropriations of money to fund his office, she ordered an evidentiary hearing on another issue. That led people to believe that if she was going to have a days-long hearing seeking evidence on some other issue relevant to the case, that she was not going to dismiss the case outright based on the Appointments Clause and Appropriation Clause arguments. And yet, the length of this opinion suggests that this has been in the works for some time. Whatever one thinks about Judge Cannon, a 93-page opinion citing case law and briefs and constitutional text does not emerge overnight. It is a serious piece of work involving the judge and likely her law clerk's assistants, but it's not something that one spends 2 weeks writing. It's something that someone spends usually several weeks writing. The other thing that really strikes me about this is just, I want to underscore how much conduct was left untouched by even the most generous presidential immunity argument that could have been applied to this case, and indeed was applied in this case. Unlike in the DC case, where no one made the Appointments Clause argument, in the Florida case, Donald Trump's lawyers both made motions to dismiss based on presidential immunity and on this argument. Judge Cannon has never held a hearing on the presidential immunity argument. In fact, several days ago, she asked for supplemental briefing on the presidential immunity argument in the wake of the Supreme Court's opinion that was due for Jack Smith and his team this coming Thursday. But as Vaughn was just talking about with you, there are, even if you think that Donald Trump's charges on classified documents emanate from his time in the White House, that is, that they were lawfully his, and that by taking them with him to Mar-a-Lago, that somehow stems in and is rooted in official conduct. There were other charges here, including obstruction of justice. based on conversations, for example, that Trump had with his then lawyer, Evan Corcoran. Vaughn was referring to them a few minutes ago. That never could have been rooted in official acts or official conduct. That evidence would have come in, and more importantly, any indictment predicated on that conduct would have been fair game, because Donald Trump was then, while a former president, a private citizen at the time of that conduct. Judge Cannon had to have had a realization that as robust as the court's decision was on presidential immunity, it would not have salvaged the case for Donald Trump, in this case, fully and outright. It would not have eliminated all of the charges. This, on the other hand, was a clean sweep. It allowed her to dismiss all of the charges. The timing in that it comes after Justice Thomas's concurrence is also instructive. And yet another victory for Team Trump legally. This has been almost unprecedented for them since July 2nd. As I mentioned earlier, not only did they get the Supreme Court's decision, but they are now having additional briefing in front of the Manhattan Criminal Court, where there will not be a sentence. There was not a sentence on July 11th. We won't see one, if at all, until September 18th. And now this, the full dismissal of all 30 plus counts against Donald Trump in this case in Florida, Jose.
And so, Lisa, help me understand this, because the judge very clearly is not ruling on issues that you just mentioned, all those other issues, right? And in her order finalizing and terminating everything, she says this order is confined to this proceeding. The court decides no other legal rights or claims, and yet in practice it does.
That's correct. I mean, it decides them in the sense that she won't be deciding them. But as I mentioned earlier, the beauty of this argument for Trump's allies was always that in rooting a dismissal based on Jack Smith's unlawful appointment, if he never had the right to be there in the first place and to indict Donald Trump, they could knock out each and every one of the charges against him, irrespective of whether any of their other arguments succeeded. And they had many. They had the presidential immunity argument. They argued that he was a victim of selective and vindictive prosecution. They argued that the search warrant wasn't properly predicated and that it contained misleading omissions to the judge who then approved the search warrant, a magistrate judge in Florida by the name of Bruce Reinhart, and so on and so forth. So there were a number of other arguments here, some of which might have been able to fully dispose of the case, but none as cleanly and neatly as this one, Jose.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.